Federal Drive is presented by GEHA, Government Employees Health Association, proudly providing health and dental benefits to federal employees and their families. Visit GEHA.com.
The Deferred Resignation Program reshaped the federal workforce, but not without turbulence. As the September 30th deadline passed, many employees were still unsure about their status, next steps, and legal exposure. Here to help us sort through the aftermath and explain what former feds need to watch for now is managing partner at Tully Rinke, Michael Fallings. Mr. Fallings, thank you so much for joining me.
Thank you for having me.
We're looking now at the Deferred Resignation Program sort of in the rearview mirror. When you think retrospectively, what was so unusual about this program and the way it was structured?
Well, I think from the beginning, how it was disseminated to employees and the structuring from that was unusual because employees were given a short time frame to make a decision on whether to enter the program. And then even after that deadline, a number of employees experienced issues as far as whether they were even eligible still for the program, whether they were violating the agreement or whether even the government was violating the agreement during that period of time. Our firm has fielded a lot of consultations and clients have retained us because of issues employees were having during the program period. And then there were subsequent offerings of the DRP to employees, which still contained unclear messaging about the eligibility for those employees and what the agreement was actually saying.
As you talked to folks who were considering taking it or took it and then lacked clarity, what were some of the biggest lessons learned or insights that you discovered as you got a better picture of the program?
I think one of the main issues, lessons learned was eligibility for the DRP and voluntary early retirement. We found there were a lot of employers that were told they were eligible for that, which then actually they weren't. So I think a lot of learning lessons for people was really not to just act so quickly without consulting with an attorney or actually doing some fact checking on their own end. I think that's probably the biggest lesson learned. I think there have been issues as well as far as just what employees could have done during the period, during the DRP period, as far as like where they were working and then like what debt was owed still to the government. There were clauses in the agreement about debt would be waived, but it turns out not all debt applied to that. And then as far as where they're working, we've had employees that started working in other locations, then were found to be in violation of the agreement. So again, it goes back to that what was in the agreement may have been, stated to be too good to be true. And really those employees didn't really, or should have done some more fact checking to confirm that they were eligible for working at a certain place or what debt they may have owed to the government was waived or not.
I want to come back to the debt and employment piece, but I want to first ask, as this rolled out, because it's sort of been on the street now for about 6 months, did you find that the government clarified any of these issues as the waiting period kind of rolled through?
Well, it attempted to. After the DRP was announced, OPM did issue a FAQ on its website, an attempt to clarify several questions. But then there were still more questions, and there was still more clarity that needed to be made. And then certain agencies were trying to deal with it on a situational basis. So they attempted to, and those agencies attempted to as those issues arose, but it wasn't across the board.
Tell us now more about the debt issue particularly. What kind of debt is at stake here, and how should employees or former feds be thinking about what they owe and what the government owes them?
Well, yes, the agreement, a lot of the agreements originally said that pretty much all debt owed to the government was waived. But as it turns out, we've had clients that are still being told they owe debt for overpayment, perhaps student loan debt. And so for those employees, now they are having to either pay that debt or seek a waiver with DFAS, of that debt or work out a payment plan. So that's what those employees could try to do now, or, they could try to challenge the debt and challenge it that they owe it, through DFAS.
I'm speaking with Michael Fallings. He's a managing partner at Tully Rinke. And one of the other issues that came up pretty frequently when the program first rolled out was whether someone who took the DRP and was basically on paid administrative leave could take other employment. How has that worked out in practice?
Yeah, it's been situational. I mean, I think some employees have been able to work, but some employees that did seek work were found in violation, or they were told they could not work at a specific location. Now, most of these agreements did say that they should consult with the agency's ethical office or whatnot, but it still wasn't exactly clear like what was off limits because they were still employees. Employees had questions during the DRP period about whether they should just resign and then take the position that they were seeking or not. And, that was, a question that some employees found that they were in trouble for because they didn't resign and they were still seeking benefits from the government. So that's how it's really played out, is just like it's been situational mainly, where some employees have been able to work and haven't suffered any issues, while some employees were found in violation are now being told they have to pay back money to the government.
Now that the program has ended, for folks who participated in it, what should they be expecting in the resolution of their claims, their discharge, their retirement? How's that playing out?
Well, now that these employees are now no longer federal government employees, they should have hopefully received their official personnel file. They're still eligible to return to the federal government if they would like to, but no, they're no longer receiving that benefit. If they are retirement eligible, then perhaps there's an annuity still coming to them. If they're not, then they're no longer receiving any kind of payment benefit, and they are permitted to work wherever they want now. If they have claims against the government, they can still pursue those. There's, again, a lot of employees that I think still have questions about whether they received their full benefit or not from the government. And for those employees, they should seek, to try to file claims regarding their benefits, whether it's with the agency itself or the Office of Personnel Management.
So the fact that the DRP ended on the day before the government shutdown began could have some consequences here. How do you think the shutdown will affect the wind down of DRP programs and the individuals affected by them?
It will likely delay any kind of processing of separations for the employee or any claims that those employees seek to file. Hopefully, it's not a lengthy delay for those employees, but with the shutdown, a lot of agencies, a lot of personnel aren't able to process paperwork, to separate those employees or to process claims that those employees were filing.
So that leaves perhaps people in a limbo status for a while.
Yeah, it does. I think there's a lot of people, DRP or not, that are in limbo status, but especially those that were supposed to not be employees as of September 30th, and perhaps are still waiting on certain documents, a last payment, perhaps, or whatnot.
The DRP was really a first of its kind program here. So people didn't know how it was going to roll out, exactly what the rules would be. As you look back at it now, what do you think are the most important lessons maybe that the government learned if they were going to try to do something like this again?
For the government side, I think, take its time and make sure they're following the correct procedures. A buyout offer, I guess, is not uncommon, at least in the private sector, when trying to reduce the amount of employees, but it needs to ensure it's complying with regulations. It needs to have a clear messaging so employees know what they're eligible for and what their rights are as well. And it needs to be consistent across the board. The government is a large employer, and there's several different agencies where agency heads were saying one thing and another agency head was saying another. So there needs to be clear and consistent messaging. I think that's a learning lesson as well.
I've been speaking with Michael Fallings. He's a managing partner at Tully Rinke. Thanks so much for the clarity around this program, but also the very practical advice.
Yeah, thank you for having me.
We'll post this interview at federalnewsnetwork.com/Federal Drive. Subscribe to the Federal Drive wherever you get your podcasts.